Good afternoon. Today I would like to give my presentation on the topic IPC. IPC. What is IPC? Where can we use IPC? What is the purpose of IPC? What is the nature of IPC? All of these questions will be covered in this video. So let's start with our topic, IPC. IPC stands for Indian Penal Code 1860. It was enforced on 1st January 1860. This particular code, that is Indian Penal Code, was drafted by the first Law Commission of India under the assent of Governor General of India in the year 1837. As the chairman of this committee, drafting committee, was Lord Macaulay, therefore he is known as the father of IPC. Now we talk about the constitutional validity of this act. This particular act is valid under Constitution's Article number 13 Clause 1 and Article 372. How many sections or chapters does this IPC covers? This IPC, that is Indian Penal Code 1860, is divided under 23 chapters and 511 sections. When we talk about the nature of IPC, this particular law comes under the category of substantive law, as it only defines the offences and their punishments. This is also a codified law, as it gives the definitions of offences and their punishments under a section number. Therefore, it is a codified law too. And when we talk about the branch of this law, then it comes out to be a public law. IPC is a public law. That means when a case is filed under IPC, then it is not filed against an individual like civil cases or civil cases like contract, IPR and others. It is filed against a state, as it is a public law, so every case under IPC is filed against the state. Now, let us go more deeper in this law. So, for going deep, let us first understand what does crime means. As we know, crime is not defined under IPC or any criminal procedure code or in any other criminal law. So we can't have a universal definition of crime, but we can understand crime as an act forbidden by law. But how can we know that a crime is committed? When an act committed or omitted by a person includes a guilty mind or a malified intention, then it is known as a crime. So the essential elements for categorizing a crime is actus rea and mens rea. Actus rea is a Latin term and mens rea is also a Latin term. Actus rea means the wrong doer, or the action which is done wrongly. Now coming to mens rea means guilty mind, an act done with a guilty mind or a malified intention. So when actus rea and mens rea is present in any act omitted or committed by an offender, then it is termed as a crime. Always remember, if actus rea is present and mens rea is not present, then it can't be said that it is a crime. Or vice versa, if actus rea is absent and mens rea is present, we can't still categorize it as a crime until and unless actus rea and mens rea combine together and in a form of act, we can't categorize any act as a crime. So I hope I am clear with this topic. Let's continue it further in another session. Thank you.